Thank you, Madam President. And thank you, Senator Kissel, and also my esteemed colleague from New Haven for your remarks. I don't know Judge Harper personally. I've never met him, though I know he has done a great deal of good throughout his life, and he has been recognized many, many times for that. By many accounts, he has also served as an outstanding judge since being elevated to the Supreme Court, and then more recently as a referee. However, on one specific and identifiable occasion, I believe he made a critical mistake. A mistake that is something that cannot and should not be overlooked or forgotten with the passage of time. Back in the 2000s, the issue of same-sex marriage was a very big issue here at this state capitol. And in a quick search that I did, I found no less than 9 proposed bills that were submitted between just 2002 and 2005. I mention this to make the point that the mere introduction of that legislation proves that this is something that falls within the realm of the law. And that I believe that in order for this to become the law in our state, it must pass the legislature and be signed the governor. And numerous times during this period, members of both parties and 2 separate governors acknowledged that fact. While all this was happening and this debate was going on here at the Capitol during that several years, there was also a court case moving through the lower courts that ultimately became the mechanism that allowed the state Supreme Court to change our law. Now, I want to stop for a second and explain very clearly for the record that my opposition to Judge Harper's reappointment has absolutely nothing to do with the issue of same-sex marriage itself. I supported civil unions when they were proposed and passed, and I believe that gay couples should have the right to marry. I do not believe, and I think most people agree with me, that religious institutions should not be forced to participate in marriage ceremonies that they disagree with. But I believe this is the current law, and I am certainly satisfied with it. My issue is not that same-sex marriage became law in Connecticut. Rather, it is how same-sex marriage became the law in Connecticut, which was by the actions of 4 individuals who were members of the Supreme Court back in October of 2008, and not this legislature. In my opinion, this is a very clear and textbook case of judicial activism. Black's Law Dictionary defines judicial activism as a philosophy of judicial decision-making whereby judges allow their personal views about public policy, among other factors, to guide their decisions. When a judge puts these factors above the requirements of law in an effort to comport with their own biases and opinions, they have stepped outside their proper role. Everyone here knows about the 3 branches of government. And the role of making laws falls to us, the state legislature. The judicial branch is not supposed to have this power. And judges are repeatedly cautioned throughout their career never to cross that line. Judicial activism usurps the power of the elected branches of government, damages our system of government and the rule of law. It's also worth noting that this concern is precisely why we are here today. The legislature's Judiciary Committee, as well as the House and Senate, are charged with confirming judicial appointments after reviewing and approving candidates based on their record and judicial temperament. If we, as members of the legislature, do not stand and protect our role among the 3 branches of government, then who will? If there's any doubt that this case was a case of judicial activism, I would ask you to consider how you would feel if a similar case came before the court today to reverse that decision. It is simply wrong for the court to make laws. The court should not be leading the public It is us, the representatives of the people, who are alone accountable directly to them, and we are subject to replacement by election. We are the ones that bring the wishes and concerns of our constituents forward to make the policy that suits them. The court's role is simply to interpret and apply those laws and not to change them. In this case, it seems like many are willing to look the other way simply because the policy matter in question is popular today. Our society is going to continue to change over time based on the will and the whims of our constituents, and so will the people that sit in these chairs. The policy of same-sex marriage was bound to happen. The proof is that I don't think anyone in this room would doubt that any one of those proposed bills would have become law between 2008 and now. There was no reason for the court to step in to make that happen. Madam President, I will be voting no on this confirmation today, and I'm fairly certain that my vote is not going to change the outcome. But that's not the same as saying it doesn't matter. It does matter. It matters because I believe someone needs to be on the record reminding this body of our role to be a check against the judicial branch when it exceeds its authority. And it matters to me. I want to be consistent always. I started my comments today by saying that we're all judged by our records. And certainly everyone in this room understands that completely. For me, this one item in Judge Harper's record excludes from his eligibility to serve on the bench. It was wrong in 2008 when it happened. It was wrong in 2011 when he was appointed to the Supreme Court, and I voted no at the time. And it's still wrong today. Thank you, Madam President.
Senator